In Medis Pharma Ltd versus NHS resolution, the Administrative Court determined two costs issues arising from a dismissed judicial review of a pharmaceutical list application refusal. First, the court refused the defendant's application to vary a permission hearing costs order from costs in the case to no order as to costs, rejecting the defendant's claim of complete neutrality. Although NHS resolution indicated it would not actively contest the claim, the court found its summary grounds of resistance had pushed back on factual and legal points raised by the claimant, distinguishing it from a truly neutral tribunal-like party entitled to costs protection under Davis No. 2 versus HM Deputy Coroner for Birmingham. Second, applying the Denton test via Liberty versus Secretary of State for the Home Department, the court refused relief from sanctions for the claimant's late-filed skeleton argument, 13 days overdue, filed as a fait accompli without seeking extension. The breach was serious, without good reason, and aggravated by improper presentation. The claimant was required to argue from its original statement of facts and grounds. The decision clarifies that defendants claiming neutrality must maintain genuinely non-adversarial conduct to secure costs protection, and reinforces strict compliance with court directions for skeleton arguments in judicial review. Quote, "At several points in the summary grounds of resistance, the defendant sought to push back on points made by the claimant, both in relation to issues of fact and alleged errors said to have been made by the committee. It would not be right, I think, to treat the defendant as having attained quite the same neutral status as a party who had taken no part in the proceedings at all, or who had merely responded saying that it was neutral as to the outcome."
For a detailed summary of this decision, visit tmclegal.co.uk.